So you inherited a house and now you're wondering, can I sell it? Do I have to go through probate? And what happens if there are multiple heirs involved? If you research Sell My Inherited House, you're not alone. This is one of the most common questions families ask after a loved one passes away. The truth is, selling an inherited home is very different from a normal real estate sale, especially here in California. I'm Paula Aragone with Aragone Associates, and for more than 23 years, I've helped families across Orange County, from Newport Beach to Yorba Linda and Huntington Beach, navigate probate sales, trust sales, and inherited properties. Strategy is what we do. Before you can sell an inherited home, the first question to answer is who has the legal authority to sell the property. When someone passes away, real estate does not automatically transfer to the heirs the moment the will is read. In California, someone must be legally appointed to manage the estate and handle the property sale. If the home was owned in the individual's name, the estate will usually go through probate. Probate is a court-supervised process where the court validates the will and appoints an executor or administrator to handle the estate. Once the court issues letters testamentary or letters of administration, that person has the legal authority to manage and often sell the property during the probate process. In many California probate cases, the sale is handled under the Independent Administration of Estates Act, often called IAEA. If the personal representative has full authority, the property can typically be sold without court confirmation, although beneficiaries must receive a notice of proposed action. If the state has limited authority, the sale may require court confirmation, which adds additional steps to the process. Now, there's another very common situation. If the home was held in a living trust, the property usually bypasses probate entirely. In that case, the successor trustee has the authority to sell the home according to the terms of the trust. Trust sales often move faster than probate because there's no court supervision, but the trustee still has a fiduciary duty to act in the best interest of the beneficiaries. One common misconception is that the property must first be transferred into the names of the heirs before it can be sold. In California, that is not necessary. In a probate sale, the executor or administrator signs the transfer documents on behalf of the estate. In a trust sale, the successor trustee signs the documents on behalf of the trust. The appropriate deed is then recorded at closing when the property transfers to the buyers. That is why most attorneys and everybody I know always say, get a trust, so much easier. Now, let's talk about something that often complicates inherited properties: multiple heirs. If there are several beneficiaries, siblings for example, disagreements can sometimes arise about whether to sell the property, keep it, renovate it, or split it. In a probate estate, the executor or the administrator generally has the authority to proceed with the sale, as long as they fulfill their fiduciary duties and follow the proper notice procedures. In a trust, the trustee has similar responsibilities to act in the best interest of all beneficiaries. Good communication early in the process can prevent a lot of unnecessary conflict later down the road. One of the most important financial concepts when selling an inherited home is something called the step-up cost basis. When someone inherits real estate, the IRS typically resets the tax basis of the property to its fair market value at the time of death. That means if the property is sold shortly after inheritance, the capital gains tax may be minimal or even zero. This is a major financial advantage and one of the reasons it's important to work with a CPA or a tax professional who understands inherited property. The next step is evaluating the condition of the property. Many inherited homes have been lived in for decades and may need repairs, updates, or cosmetic improvements. Before deciding how to sell, it's helpful to understand, number one, the condition of the home, number two, the potential market value, number three, whether strategic improvements could increase the final sales price. This is where a comparative market analysis from an expert real estate agent who specializes in probates and trust becomes critical. Sometimes selling as is the right decision. Other times, strategic preparation can significantly increase the net proceeds to the estate. Once the property is under contract, the closing process is similar to a traditional real estate transaction. The title company will review the estate documentation. Depending on the situation, that may include, if we're on probate, letters testamentary or letters of administration, any probate notices. If we're in trust documents will need to be provided, death certificates, and so on. The goal is simply to confirm that the person signing the document has the legal authority to sell the property. Selling an inherited home involves more moving pieces than a traditional real estate sale. But when it's handled strategically, the process can be much smoother for everyone involved. At Aragone Associates, we work with families across Orange County, including Newport Beach, Laguna Beach, Irvine, Huntington Beach, Anaheim Hills, Yorba Linda, and more, helping them navigate probate sales, trust sales, and inherited property decisions. Our goal is very simple: maximize value and minimize stress. If you're navigating an inherited property and want guidance from a team that specializes in this area, my contact information is in the description below. And if this video was helpful, please subscribe. We regularly share practical guidance for families dealing with probate, downsizing, and any major real estate transitions. I'm Paula Aragone, and I'll see you in the next video.